Welcome to the Deep Dive. We're here to pull out the key insights you need to stay ahead. Today, we're tackling a really central topic in India, reservation policy. It's always evolving, always debated, and right now, there's some big news making it essential to understand, especially if you're tracking current affairs or, say, prepping for exams.
Exactly.
We've got two main things on the radar. First, Tejashwi Yadav's proposal in Bihar, talking about an 85% quota. That's quite a number.
It certainly is. And second,
The Supreme Court, they've just issued a notice about applying the creamy layer concept, excluding the better off to SC and ST reservation.
right. And what this really underscores is that reservation in India isn't some static chapter in a textbook. It's a live issue. It's where the Constitution meets social goals, meets political reality. So for anyone studying for UPSC or similar exams, getting these nuances is critical. It's about understanding the framework as it actually operates.
Okay, let's build that foundation then. Before the headlines, what does the Constitution itself say? Equality is fundamental right, but how does that square with reservations?
Yeah, good place to start. You look at Articles 15 and 16, they're the bedrock guaranteeing equality for all citizens. Think public jobs, education.
Standard equality.
Well, yes, but there's a key distinction. There's formal equality, treat everyone the same, where reservations might look like an exception. But then there's substantive equality.
Okay.
And that's where the Constitution, in those same articles, allows the state to make special provisions for OBCs, SCs, STs groups facing historical disadvantage.
So it's about leveling the playing field, not just stating everyone's equal on paper.
Precisely. Substantive equality sees these provisions not as exceptions to equality, but as tools for achieving real equality, correcting for those historical hurdles,
Got it. That's a crucial difference.
Yeah.
So how does this translate into the actual numbers we see today? At the central level, what's the current setup?
Okay, centrally, the structure is OBCs, other backward classes, they get 27%. Scheduled castes, SCs, get 15%. And scheduled tribes, STs, have 7.5%.
And the EWS quota?
And then there's the 10% for the economically weaker section, EWS. So add that up.
That's 59.5%, almost 60%.
59.5% essentially. But remember, this isn't uniform across the country. State percentages can and do vary quite a bit.
Right, important point. Now, this whole structure, these percentages, they didn't just appear. The courts have played a massive role, haven't they?
Oh, absolutely fundamental. Judicial interventions are key to understanding this. You can trace a whole evolution through Supreme Court cases.
Let's walk through some major ones.
Okay, maybe start with Balaji versus State of Mysore back in 1962. That's where the court first said reservations need reasonable limits. Basically, it introduced the idea of a 50% cap.
The famous 50% ceiling.
Yes, rooted in that formal equality idea, perhaps. Then, fast forward to State of Kerala versus N.M. Thomas in 1975. This one shifted the perspective a bit.
How so?
It didn't explicitly overturn the 50% rule, but it framed reservations as an assertion of equality, moving towards that substantive goal we talked about, not just an exception.
Interesting shift in philosophy.
Definitely. Then comes the big one, Indra Sawhney in 1992. Hugely important.
What did it establish?
It upheld the 27% OBC quota.
Yeah.
Crucially, it also reaffirmed that 50% ceiling, though allowing for, rare exceptions. And importantly, it introduced the creamy layer principle for OBCs.
So making sure the benefits target the less privileged within the OBCs themselves.
Exactly, excluding the more affluent sections. And then, much more recently, you have the Junhit Abhiyan case from 2022.
That was about the EWS quota, right?
Yes. It upheld the 10% EWS quota, which is based purely on economic criteria. And it also clarified something about the 50% cap.
What was the clarification?
It suggested the 50% ceiling from Indra Sawhney applies mainly to the reservations for backward classes, SC, ST, OBC, but maybe not strictly to the EWS quota, which it saw as a separate category.
Okay, wow. So these cases provide the context for everything happening now.
Absolutely. You connect those dots, and today's headlines make perfect sense. Tejashwi Yadav's 85% proposal directly challenges that 50% ceiling reaffirmed in Indra Sawhney.
And the Supreme Court notice.
It brings up that other key aspect from Indra Sawhney, the creamy layer, and asks whether it should logically be extended beyond OBCs to SCs and STs as well. That's really a complex, sensitive debate.
So we're basically seeing two core questions being actively debated right now. Can quotas go beyond 50%? And should the creamy layer apply to SCS and STs?
That's the heart of it. It shows this policy area is constantly being pushed, pulled, and reevaluated through politics, social justice concerns, and of course, judicial interpretation. It's very much alive.
It really is. Which brings us to a final thought for you, our listener. Given this history, these legal precedents, and the current political moves, how do you think India can best balance the need for historical justice with contemporary demands for equality, ensuring genuine opportunities for everyone in this dynamic landscape? Something to think about. Thank you for joining us for this deep dive.